Nathan from Farm Credit looking for a job.
Oh, okay.
Morning, we are on the record.
All right, I'd like to call the October 21st, 2019 meeting of the Tennessee Real Estate Appraiser Commission to order. Before we get into the agenda, Roxanne, do you want to make an introduction to us?
I do. Thank you, Chairman Thomas, for letting me do that. First of all, we have notified the public of this meeting. Notice of the October 21st Real Estate Appraiser Commission meeting was posted on October the 16th. And I would like to introduce your new Executive Director, Jennifer Peck, who I'm smiling is going to be taking this program. I am going to miss you all immensely, but this is a fantastic move. Jennifer is an attorney, so if you do have questions, she can jump in on some of those, but otherwise Anna has all of that experience covered. But this is going to be a great move. 6 of my programs are moving over to her. She's already had a meeting with the architects and engineers, has yours, and then land surveyors and 3 other smaller programs. So I'm here to help her and you all as long as you need me, but she's got it from here on. So we welcome her. And if you haven't had a chance to chat with Jennifer after the meeting, she'll be here to make sure to meet everybody.
Thank you. Thank you very much.
Mr. Chairman?
Yes.
I'd like to let the record reflect that we really appreciate the hard work that's been done by Roxanne, and we wish her well. And
Thank
we
you.
welcome our new director.
Thank you. She is going to do fantastic. So I'll turn it back over to you, Mr. Thomas.
Thank you to both of you. One coming, one going. But you're both smiling, see, so that's a good thing.
Yes,
So-
and I'm not going anywhere, but
Okay.
I'll visit every now and then.
All right, we want to have the roll, Roxanne,
Absolutely. Randall Thomas,
here.
Dr. Warren McCara,
Here.
Rex Garrison,
Here.
Jim Atwood,
Here.
Jason Bennett,
Here.
Brett Mansfield,
Here.
Michelle Alexander. Here. All here, and you have quorum. Thank you.
Thank you very much. We need to adopt the agenda. You've had the agenda sent to you. Some of you have a paper copy in front of you, I think. We don't have any corrections or additions to it, do we, Roxana?
Not that I'm aware of.
Okay, all right. All right, we want to review the minutes from the July 15th meeting. Those have been sent to you. Anybody have any corrections or additions or subtractions to it? Entertain a motion to approve those minutes.
I move we accept the minutes.
Second.
Motion's been made and second. Any discussion? All those in favor of approving the minutes from July 15th, say aye.
Aye.
Any opposed? All right, motion carries. We'll approve the minutes. Experience reviews.
That starts on page 21 on your iPads.
You want to go through those, Roxana?
Absolutely. Give me a
Okay.
minute to get to that page. And I'll go just call out each individual and the people that you have under you. So we'll start with Chairman Randall Thomas. You had Andrew Brian Cole,
Yes.
Cody May,
Yes.
and James William Sell II.
Yes.
You had one additional individual, Kim Poor.
Yes, she came today. Yes. Can I just ask a question?
Absolutely.
Mr. Sell
Yes.
has been a licensed appraiser for 21 years, 16 years, something. I mean, he's as knowledgeable as probably more so than I am. Is it statute or rule that moving from license, if you're active, to certified, you have to have that interview? That just seemed to him, and even to me, even though we met in East Tennessee, to be somewhat of a stumbling block that realistically, was unnecessary.
Right. Well, I think it's intentionally designed. We discussed before, we're not going to have that circumstance very often. You're not going to have someone that practices for 16 years and wants to upgrade. So if we were to make that portion optional, it would be it's going to be on a case-by-case basis. It's unfortunate for the individuals that you interviewed today, but normally you would want to interview someone based on their experience because it's going to be a lot closer in time. So I just think, unfortunately, we have individuals just based on the way that they use their license that fall into that kind of circumstance.
That's
So
fine.
I don't think it'll happen
All right.
very often.
Thank you.
Thank you. Next, Mr. Jim Atwood, you had Jalen Banks,
Yes.
Andrew Stephen Wiggett,
Yes.
and Justin Terry Hugh.
Yes.
All yeses. Thank you. Next, we have Rex Garrison. Yours are Stephen Duncan.
Yes.
Thank you. John Austin Hicks,
Yes.
Thomas Vondren,
Yes.
and I believe today you did two, Jonathan Weber,
Yes.
okay, and Lance McElroy.
Yes. And on Lance, he's going to get me 2 more reports that I'm going to review.
So is he a tentative yes, pending those
Yes.
reports?
Mhm.
Okay, that's what we will do then. We will wait to hear from you before releasing it, but on the record, at least now, we reflect that you're approving all of them. Thank you. Next, Mr. Brett Mansfield, you have 2, Jeremy Lynn Hunley
Yes.
and Joanna Morgan.
Yes.
Thank you. And Michelle Alexander, you have Mr. Adam Brett Bowers.
Yes.
Thank you. That takes care of the interview experience.
Would it be the pleasure of the commission to vote on all of these at the same time?
Yeah.
That be okay? All right, Chair will entertain a motion.
Move to accept the
Motion's been made.
recommendations.
Second.
Second.
Any opposed? Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Thank you very much. And we'll wait to hear from Rex on the one he had. Education is next. Dr. McCara?
Yes, you have the list of courses. There were 23 regular courses, 4 individual course applications, and 3 instructor applications. The 23 regular courses all are continuing education. 2 are online, and the other 21 are a traditional classroom. A couple things I wanted to point out here. If you look at course 2304 by Joe Neighbors, you'll notice there's question marks there. When I got that report, it consisted of the cover page and the instructor approval page that was blank. Okay, so I sent it back, and you'll notice at the very bottom of the list on the first page there, you'll see that same course, but it says revised. And so the missing information was provided, and I approved that course. The one that I'm denying is 2322, 2019 Annual Education Conference. There didn't seem to be any information that it was really specifically for appraisal. It had to do with active shooter awareness. Which is a nice thing to know about, but I'm not sure it's something that ought to be part of an appraiser's education that is for approval here. So my recommendation is approval of all the courses that are listed and except that 2322 and the individual course applications and the instructor applications.
And if I could interrupt just for a second, on the second page, which is on your iPads, on page 23, that you have for additional courses with instructor approvals, the last one on Dana Thornberry, that one you did approve as well, but on your iPads.
Okay, that didn't make it, okay, yes.
But it is
that
also approved.
Right,
Thank you.
that was my error.
Heard the comments from Dr. McCara on education. Anybody have any questions for him? Or the committee. You want to make that a motion, Doc?
Yes, I move that the report be accepted.
Okay.
A second.
Motion been made and second that we accept the education. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. Thank you, Dr. McCara. We have a hearing.
We do, sir, and I will turn it over to Anna. I have on your iPads appearing before the board. In case anyone does appear in person, we always want to have that spot available. But Anna, if you want to do the rulemaking hearing next, or do you want to move on with the legal report first?
Which one would you like? Rulemaking hearing or the legal report?
Is there anyone here that could leave after the hearing
I mean, if anyone's here for the hearing, they can leave afterwards, so we
Okay.
can go ahead and do the hearing first.
That would be the only thing I would
Okay.
throw out.
That'll be fine. Let's do the hearing yet.
All right.
Your documents for the hearing, I believe we've got paper copies if anybody wants them, but on your iPads, you start on page 59.
So this rulemaking hearing is called to order. My name is Anna Matlock. I serve as an Associate General Counsel in the Department of Commerce and Insurance, Division of Regulatory Boards, and I represent the Tennessee Real Estate Appraiser. Would the agency representatives who are present introduce themselves for the record? Board. If you'll begin with the board members.
Brett Mansfield.
Rex Garrison.
Randall Thomas.
Jim Atwood.
Jason Bennett.
Warren McCarra.
Michelle Alexander.
Our Executive Director.
Roxana Gamusio.
Jennifer Pegg.
Today is Monday, October 21st, 2019. This rulemaking hearing has taken place pursuant to Tennessee Code Annotated Section 4-5-204 and Room 1B of Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. The purpose of this rulemaking hearing is to solicit comments on proposed rules the Commission has made public in order to allow applicants for state licensed, certified residential, and certified general real estate appraisers to complete certain qualifying education specifically identified by the Commission via distance education. To accomplish this change, the rules remove the word classroom from the current rules as this has previously been interpreted by the Commission to exclude distance education. Additionally, the rules impact continuing education for licensees. The rules allow for no more than 1/2 of real estate appraiser license, certificate, or registered trainees required continued education credits to be taken via distance education course. Lastly, the rules reduce the supervisory appraisers course from 7 hours to 4 hours and allow this course to be taken via distance education. A rule is defined as an agency statement of general applicability that implements or describes law or policy or describes the procedures of practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State, notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, then end of which time will be the effective date. Those members of the public wishing to speak should sign up at the table in the front of the room. Only those who have signed up will be permitted to speak. Oral comments will not be accepted from persons who have not signed the sign-in sheet. Is there anyone that desires to offer oral comments but who has not signed the sheet? Seeing that there are none, I would call your attention to the sign-in sheet located at the front. On the table behind me, there are red-lined copies of this rule on the table. The notice of rulemaking hearing included the entire text of the proposed rules and was published on the Tennessee Administrative Register website on July 19, 2019. Ms. Gamusio, what additional notice was given to the affected individual groups?
The office notified anyone signed up for email notifications on August the 1st, 2019, and that is the standard process for Commerce and Insurance, as well as the notice of the meeting taking place today, hearing listed on the agenda.
Thank you. As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. I will read the substance of the proposed rules into the record. So the proposed rules notice beginning with Rule 1255-01-.051B. 1 is changed to remove the word classroom. B1I capital 1, the Commission shall grant an applicant credit towards the qualifying education requirement for the National Standards of Professional Appraiser Practice course only when at least one of the course is changed from instructions to instructors. We have added a new subsection 2 Courses listed in B1I2 and 3 may be taken via distance education. Just for clarification purposes, those courses are the 15 hours of National Uniform Standards of Professional Appraisal Practice course, the 30-hour course in Appraisal Principles, and the Appraisal Practice or Procedures course. Also, we have renumbering from 3, 4, and a change of where to if 5. The next change will be removal of the number 6 and replacing it with number 7 with the new language reading. In the event of a denial, an applicant for a license may file a written request for reconsideration with the Commission. The Commission shall reconsider the request for reconsideration and reevaluate the applicant's education. In the event that the application is denied after reconsideration, the denial shall not create a contested case as defined by the Uniform Administrative Procedures Act, TCA Section 4-5-102. The applicant may reapply for a license. The next section of the rule that is being changed is Rule 1255-01-.071B. We have an addition in Part B to add the words real estate. We have removed from number B1 the word classroom, and we are including which shall include in place of these modules shall include. The next change will be in B110, which shall say successful completion of 20 hours of appraisal subject matter electives, which may include any hours over the minimum listed in little I through X. Number 2 is also mirrors language before. We have added courses listed in B1, I, 2, and 3 may be taken via distance education. And number 5 is added to saying the qualifying education requirement may include the 150-hour qualifying education requirement for the state licensed appraiser classification. We're removing the former number 5, and number 8 is amended to read, in the event of a denial, the applicant for certification may file a written request for reconsideration with the Commission. The Commission shall consider the request for reconsideration and reevaluate the applicant's education. In the event that the application is denied after the reconsideration, the denial shall not create a contested case as defined by the Uniform Administrative Procedures Act, TCA 4-5-102. The applicant may reapply for a certificate. The next section that's being changed is Rule 1255-01-.081B. We are changing that rule to clarify the qualifying education requirement, and we've added number 2, just rephrase some of the words to state the successful completion of the 15 hours of the National Uniform Standards of Professional Appraisal Practice course or its equivalent. As stated before in these rules, we've added a new number 2. Courses listed in B1, 1, 2, and 3 may be taken via distance education. And we changed number 5 to add that an applicant's qualifying education requirement may include 150 classroom hour requirement for the licensed real estate appraiser certificate or the 200 requirement for the certified residential real estate appraiser classification. Number 7 changes to may to should and adds qualifying. And then number 8 adds the additional language stating that a written request for reconsideration shall not constitute a contested case hearing. The next section is going to be Rule 1255-01-.12. That is amended to number E removes an approved 30 and approved as well, and then it says or its equivalent as determined through the AQB. These courses may be taken via distance education. Number F is just a cleanup. There's no substantive changes there other than removing the 7-hour course to 4-hour courses. G is added, an applicant should refer to Chapter 1255-02, Evaluation of Education, for further delineation of qualifying education requirements. Next change is going to be found in number 7 for continuing education. In 7A, we have removed the word classroom. 7C, we have removed the word classroom and replaced it with course. 7D, we have removed the words only where and replaced it with if. And then 7H, we have added the language that a registered trainee may complete no more than 1/2 of the individual's required continuing education credits via distance education. Number 10C1 states that has added the language or until the supervising appraiser determines the registered trainee is competent to inspect the property in accordance with the competency rule of the Uniform Standards of Professional Appraisal Practice, in parentheses, USPAP, for the type property. And next, we will have a change in 10G, which states supervisory appraisers shall be required to complete a 4-hour reduced from 7-hour course on responsibilities of supervisory appraisers and trainee appraisers. The course shall be completed by the supervisory appraiser prior to supervising a trainee appraiser. Next, we have changes in the continuing education chapter. So we'll have a change in Rule 1255-04-.01. 1 is changed to remove instruction and replaced with courses. 1B, where, is removed and replaced with the word if. D, which cover real estate appraisal related topics such as, is stated to say which are consistent with the purpose of continuing education stated in paragraph 6, and cover real estate appraisal topics such as. And the last change we have is Rule 1255-04-.01 is amended by adding a new paragraph 8, which states a licensee or certificate holder may complete no more than 1/2 of the individual's required continuing education hours via distance education. Before I take public comments, I will read comments that I have received via email prior to this hearing. So the first comment I received is from Mr. Mark Gibson. It is from August 1st, 2019. It says, I am sending this letter to voice my support for the change proposed, and I support distance education as well, defined lower supervisory class hours. To find in classroom coursework that is both relevant and not repetitive is challenging as best in the particular market, and being able to expand into distance education opens doors for more formal and needed courses that are relevant to the appraiser for the appraiser to complete. Do we have a comment from the commission for that comment? Seeing that there are none, I will read the next comment that I have received. It is from Miss Nicole Andler. She's a compliance manager for On-Course Learning Real Estate LLC. She has stated the proposed rule, which for continuing education, and has proposed to add 8. She has given a summary of the comments, and then her comment she gave to me is, first, it will make it challenging for industry professionals to meet the continuing education requirements to maintain their license. For working professionals, distance education allows for flexible scheduling for those with irregular work schedules or family responsibilities. Professionals will no longer be able to complete their continuing education requirements on their own. Second, distance education allows for students to complete their education at their own pace. without waiting for a slower paced classroom or rushed ahead before they meet learning objectives. In addition, distance education is easily accessible for those with restricted mobility and the flexibility to study in a convenient location with an internet connection. As a result of the proposed rule, students will be limited in their ability to complete their continuing education if they have a restricted schedule and number of licensees able to maintain their license could decline. In addition, education providers could be forced to increase prices for distance education due to potential sales being cut in half. Are there any comments from the commission?
You want to comment?
Sounds like she's talking more about CE and there was no change in CE.
Any additional comments? Okay. Ms. Camiscio, were any written comments received by the commission office regarding these rules?
No, none have been received.
Okay. Are there any public comments from those present at today's meeting?
There are none that have signed up.
Any comment from the commission?
Anyone?
Yes. Question. I don't know. It's on page 3 of my documents, number 7. In the event of a denial, an applicant for a license may file a written request for reconsideration with the commission. Commission shall consider the request for reconsideration, reevaluate the applicant's education, etc. My question on that one is, why? What would be the reason we deny and would give them the right to be reconsidered? I'm not sure I understand that one.
So this would be a denial. Denial of a course. I don't believe there would be circumstances in which a person would be denied, but according to the Uniform Standards of Administrative Procedure, the Uniform Administrative Procedures, if a denial is given, then individuals have certain rights, which include requesting reconsideration from the commission, and then it's up to the commission, your purview, to determine if you would approve or disapprove the person. This is also just meant to say that that doesn't mean it's a contested case hearing, so it won't come before an administrative law judge. So if you were to deny it, that would be the end, and the licensee would have to reapply.
A second question is on page 4. And this would be small Roman numeral 10, it looks like. Successful completion of 20 hours of appraisal subject matter electives, which may include any hours over the minimum listed in one. It's kind of been my understanding that there were certain courses only that could be taken for electives, but is this saying you can basically take anything as an elective?
No, this is more of just like a clerical change. If you'll see in the red, it says these may include hours over the minimum shown above in the other modules. So we're just rephrasing how it's written. So these specific electives will still count. It's just
Specific electives, I'll rephrase, the electives are limited to those specifics and they're not open to any course.
right. This is not changing anything about the electives. It's just a grammatical change into this portion of the rule.
And one other question, I don't know if it regards the changes or not, but it's a question. Half CE, they can take half of their CE hours online. Does that include 7-hour USPAP? They can take 7-hour USPAP online. Okay, thank you.
Are you referring to number 8 on like the
Just
last
asking a
page of the
general question.
document?
It didn't really deal with any specific thing other than if they take, we have to take 28 hours CE, 14 can be online, can 7 of those 14 be USPEP is my question.
I would assume yes, that's correct. Since there's no specific courses that are outlined.
And just one point of clarification on item 5. It says 150, but it has 15 in
Yes.
parentheses.
That was
Okay.
pointed out to me. I'll fix that. Thank you. So comments?
Just some clarification that
Okay.
may eliminate confusion down the road. If this goes into effect and we don't know when it'll go into effect, is that correct?
So it will go into effect if the rules pass this rulemaking hearing, then we will put it on another form, and it will be submitted to the Attorney General's office for signature. And once that's done, it will be filed at the Secretary of State's office, and then it'll have a 90 days out from that filing. And once that's done, we'll send out another e-notify that has a link with the filing and will give you the proposed effective date. After that, the rules will be presented before the Government Joint Operations Committee. Receive a positive recommendation from that committee, the rules will become effective.
Okay. So I'm going to pick just a date, say March 1st, April 1st, that this goes into effect. If someone takes an online class now to meet these requirements, will that be counted before the effective date, or can they not take the online education till after this rule is approved?
So the rules are not effective until the effective date. Therefore,
I'm sure there's going to be a lot of questions come up once this is passed, and just wanted to clarify that.
yes, so once they're effective, then these rules will take place, otherwise the current rules still apply.
Anna, you made a comment that the effective date will be proposed. Who proposes that?
So once it's filed with the Secretary of State's office, they calendar it for 90 days after filing, and then they give us an effective date. So hypothetically speaking, if these rules, I don't foresee them being an effective date until 2020, especially since we have less than 90 days left in the year. So we'll probably, I'm estimating maybe February or March for an effective date. That's just an estimation.
And for clarification, this still does not put us in compliance with the federal statute, which you discussed at the end of that last meeting, that we are not supposed to have any rule that's more stringent than a federal rule.
Right. So we're not out of compliance with the federal government with these rules. We had the audit in January. Nothing was brought up about continuing education courses or qualifying education courses online. We're in compliance as it is. This will put us, we'll still be in the same place.
Okay, but the federal rule is that you can take all education online. Yes? No. That's what was said last time.
Yes, so it says that you can take all courses online, but that states are required to have their own state-specific requirements, which we have a few more that are a little bit different from the federal government, but we're not out of compliance with them.
Okay, but we do have a statute that says we're not supposed to have any rule that's more stringent than a federal. That's what you had said.
Correct. So technically speaking, that means I interpret that rule to mean we don't require more qualifying education or more continuing education as required by the government, by the federal government. It does not, I don't interpret it as the manner in which that education is distributed. We are more stringent than a lot of other states, but this rule will put us, closer to the other states with online education, but still a little bit behind. So that's not an area of concern with the commission at this time. But yes, to answer your question, yes. But no, we're not out of compliance. The answer is yes, but it is also no.
Okay.
I just want to make a comment about, it's sort of been interesting. I've been on this board for a very long time now, it seems, and it's been interesting to watch the evolution of thinking about online courses. When this came up a number of years ago, the feeling was, online courses, no, they're terrible, they're horrible, we can't have them. Now that we're hearing more and more practicing appraisers saying, it's really hard to complete my continuing education without access to online courses. We want to see more of them. So it's nice to see that at least the appraisers can take up to 50% of their, is that right, 50% of their continuing education courses as online. I would predict, of course I'm an economist, so you can take that for what it's worth, but I would predict that one of these days it'll be kind of like you were saying, there will be no limitations on that. We'll see what happens, but I really think it's been interesting to watch that change over time from, and I think it has to do with the age of the appraisers who are coming along, who have been educated through college and graduate school even with online courses. So these are not as alien as they are to some of the folks who may have had all their coursework as in person.
Anything further? Okay. That concludes this rulemaking hearing. Thank you for being here today. However, we have some provisions that we will need to adopt separately by motion and roll call vote. As part of the rulemaking hearing process, we have to place the rule onto another form. So there we will need to adopt the hearing language will be adopted. First motion will be to adopt the hearing rules language as presented, with the amendment of changing from 15 to 150 hours in that typo that I made. So I'll need a motion to accept the rulemaking language as.
So moved.
Second.
Motion's been made and second to adopt the rules, hearing rules language.
These will each be roll call votes.
Any discussion? Okay,
Thank you. Randall Thomas,
yes.
Dr. Warren McCara,
Yes.
Rex Garrison,
Yes.
Jim Atwood,
Yes.
Jason Bennett,
Yes.
Brett Mansfield,
Yes.
Michelle Alexander,
Yes.
all in agreement.
Okay, the next will be to adopt the regulatory flexibility addendum / economic impact statement. I'm going to read that into the record. The proposed rule would positively benefit small businesses in the real estate appraiser industry by allowing current licensees and future licensees the opportunity to take certain courses via distance learning. Allowing distance education will lessen financial costs associated for licensure in the industry in both the initial application process and during the licensure period. However, it is difficult to determine the precise number of small businesses that would be affected by the proposed amendment because the Tennessee Real Estate Appraiser Commission does not directly regulate those businesses. Rather, the Commission governs the 2,309 licensees who work for those businesses. Additionally, pursuant to TCA's Section 62-39303, 62-39312, and 62-39113, applicants must meet the current requirements for licensure as set forth by the Appraisal Qualifications Board. The Commission knows of no other less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of this proposed rule. The proposed amendment would require minimum, if any, cost for compliance. Numerous states have adopted these continuing education and USPAP standards. Thus, the proposed amendments would make Tennessee rules consistent with the federal standards and rules in other USPAP states. The Commission does not foresee any impact to consumers with the promulgation of the proposed rules, and exemption of small businesses would not be beneficial. Does anyone have any comments to the regulatory flexibility addendum?
Vote.
Yes.
Anybody have any questions? Do we need to put that in a motion? Yes. Okay, motion.
So moved.
Second.
Motion been made and second. Any discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries.
We don't need a roll call.
Oh, I'm sorry.
I will,
I'm
thank
sorry.
you, no worries. Chairman Randall Thomas.
Yes.
Dr. Warren McCara.
Yes.
Rex Garrison.
Yes.
Jim Atwood.
Yes.
Jason Bennett.
Yes.
Brett Mansfield.
Yes.
Michelle Alexander.
Yes.
All in agreement. Thank you.
Okay, the next will be to adopt the impact on local government statement pursuant to Tennessee Code annotated section 4-5-228. And that statement reads, the Tennessee Real Estate Appraiser Commission foresees no impact on any local governments. That's
It?
yes.
Okay, anyone make a motion?
So moved.
Okay.
Second.
Motion been made and second on the local impact statement. Roxanna?
Sir. Chairman Randall Thomas.
Yes.
Dr. Warren McCara.
Yes.
Rex Garrison.
Yes.
Jim Atwood.
Yes.
Jason Bennett.
Yes.
Brett Mansfield.
Yes.
Michelle Alexander.
Yes.
All in agreement. Thank you.
Okay, the next that we'll have to complete is the additional information required by the Joint Government Operations Committee. All agencies, upon filing a rule, must submit the following pursuant to TCA Section 4-5-226 I-1. A is a brief summary of the rule and the description of all relevant changes and previous regulations effectuated by such rule. The answer is as follows. The rules allow for applicants for state licensed certified residential and certified general real estate appraisers to complete certain qualifying education specifically identified by the Commission via distance education. To accomplish this change, the rules remove the word classroom from the current rules, as this has previously been interpreted by the Commission to exclude distance education. Additionally, the rules impact continuing education for licensees. The rules allow for no more than one-half of real estate appraiser license certificate and registered trainees required continued education credits to be taken via distance education. Lastly, the rules reduce the supervisory appraiser course from 7 hours to 4 hours and allow this course to be taken via distance education. B, a citation to and brief description of any federal law or regulation or any state law or regulation mandating promulgation of such rule or establishing guidelines relevant thereto. The response. Title 11 of the Financial Institutions Reform, Recovery, and Enforcement Act of 1989 requires that the appraisers performing assignments in federally related transactions meet the qualifications set by the Appraisal Qualifications Board of the Appraisal Subcommittee. C. Identification of persons, organizations, corporations, or governmental entities most directly affected by this rule, and whether those persons, organizations, corporations, or governmental entities urge adoption or rejection of this rule. The response. The proposed rule would affect current licensees and future applicants. We believe that all affected would approve of the adoption of these rules because the proposed rules are beneficial to all industry members. D. Identification of opinions of the Attorney General and reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. Response. There are no known opinions of the Attorney General and reporter or any judicial relate to this rule. E. An estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasonings upon which the estimate is based. An agency shall not state that the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget or $500,000, whichever is less. Response: there is no foreseeable probable increase or decrease in state and local government revenues and expenditures resulting from the promulgation of this rule. F, identification of the appropriate agency representative or representatives possessing substantial knowledge and understandings of this rule. The response is myself, Anna Matlock, Associate General Counsel for the Tennessee Real Estate Appraiser Commission, and Jennifer Peck, Executive Director for the Tennessee Real Estate Appraiser Commission. G, identification of the appropriate agency representative or representatives who will explain the rule at a scheduled meeting of the committees. The response is Anna Matlock, Associate General Counsel for the Tennessee Real Estate Appraiser Commission, and Jennifer Peck, Executive Director for the Tennessee Real Estate Appraiser Commission. H provides the office address, telephone number, and email address of the agency representative or representative to explain the rule at a scheduled meeting of the committees. And I've listed Anna Matlock's information and Jennifer Peck's information. I, any additional information relevant to the rule proposed for continuation that the committee requests. The response is there is no additional relevant information. That concludes that section. So we'll need a motion.
Heard Anna. Motion.
Move to accept.
Second.
Second.
Motion been made and second. Roxana?
Thank you. Chairman Randall Thomas. Dr. Warren McCara.
Yes.
Rex Garrison.
Yes.
Jim Atwood.
Yes.
Jason Bennett.
Yes.
Brett Mansfield.
Yes.
And Michelle Alexander.
Yes.
All in agreement. Thank you.
Thank you. Thank you. Following this hearing, the rules will be put on a rulemaking filing form SS-7039 and submitted to the Attorney General's office for review and approval. Once the Attorney General's signature is obtained, these rules are filed with the Secretary of State and generally become effective 90 days from the date of filing. This concludes the public comment section and the rulemaking hearing. Thank you.
Thank you, Anna. Anybody have any questions for her before we want to ask you to repeat what she said, Jim?
Yeah, I was going to say, could you repeat that?
Okay. Go ahead. You have a question?
No.
Oh, okay. So that takes care of all the rulemaking?
Yes, the
Okay.
rulemaking hearing is now concluded.
Okay. Let's take about a 10-minute break.
Thank you.
All right.
All set.
Call the meeting back to order. Move on to the legal report.
I was going to suggest, since we're on this rule train, that we might want to start on page 44, and these particular rules, obviously Anna would drive, these are proposed rules, so this is the first time that you're seeing these, unless you want to break and prefer the legal report.
Just for clarification, you have seen these rules before. We just have a question about the rules.
Oh, that's right, that's right.
So if you go to proposed rules begin on page 44 of your iPad, but we'll be specifically talking about page 50 on your iPad. If you're looking at it, there's a little I on the page at 7. It's the highlighted portion. So these rules were, we submitted them because we realized that it was out of compliance. There's a little bit of overlap in the rules. So let me explain that first. So we did 2 separate packages. We're changing some of the portions of the rules that we just did in the rulemaking hearing and then this part. I separated them in case that the rulemaking hearing kind of did not go well. Start those rules over if it needed to happen. But these are proposed rules because they're not supposed to be controversial and need to be changed because of an audit finding. So if you remember, registered trainees are required to complete 500 hours of acceptable appraisal experience, but our rule was missing the competency language in USPAP. So we had said it's number C1, 10C1, accompany the registered trainee and personally inspect each subject's property with the registered trainee and all assignments until the registered trainee has completed 500 hours of acceptable appraisal experience or until the supervisory appraiser determines the registered trainee is competent to inspect the property in accordance with the competency rule of the Uniform Standards of Professional Appraisal Practice for the type property. And below, you'll see that the area in red was marked out and it was moved to a second subsection for clarity purposes. So the second subsection is what the portion I want to talk about. So this says, if the subject property is located more than 50 miles away from the supervisory appraiser's office, the supervisory appraiser must accompany and personally inspect the property with the registered trainee, even after the registered trainee has completed more than 500 hours of acceptable appraisal experience, or until the supervisory appraiser determines the registered trainee to be competent in accordance with the competency rule of the Uniform Standards of Professional Appraisal Practice. So the rulemaking how it goes is, I know you are familiar, I just want to state it for clarity purposes. We draft rules, you vote on rules, and then the rules leave this office once our internal justification process, they're approved. And then once they're approved, they go to the Attorney General's office for pre-review for constitutionality. And if it's approved without any constitutionality process problems, they are then sent to the governor's office for approval. And during this approval process, since we are changing this section, there were questions specifically about the 50 miles away from the supervisory appraiser's office. So I wanted to talk to you all about that section of the rule. According to my research, this section of the rule was added back in 2005, specifically the 50-mile portion. And this portion is not required by USPAP or required anywhere by the ASC. This is a state-specific requirement. So it was brought up during the review process to see if this section of the rule could be removed from the requirements. So it would not require a supervisory appraiser to accompany their registered trainees with them if the subject property is 50 miles outside of where their supervisory appraiser is located. So it wouldn't say that in rule, but obviously supervisory appraisers still have the ability to accompany their registered trainee wherever, because you're ultimately responsible for for what they're doing. So I didn't know a lot of where this portion of the rule came by, where it came from in the industry, if removing it would be an issue or not. So I wanted to get your thoughts and opinions on whether it would be okay if the 50-mile requirement was removed.
What was the purpose of that in the first place? Anybody?
I don't know. Back in 2005, the information that we do, all of those questions and answers that we provided, that wasn't required back when rules were drafted. So I don't know where it came from. I do know that maybe 2 or 3 other states have this requirement as well, but most of the other states do not have this requirement within their rules. So I'm not sure where it came from. I don't have an answer. So if someone knows why it is there or has any particular feelings about it, I would love to hear about it.
The red that's been marked out,
Yes.
that is the rule now.
So the red is what it was now. Actually, the red was just moved down to the highlighted portion. It was made into a subsection.
My question is, the subsection is the proposal.
Right. So no, the subsection is moving. So the portion in red was marked out and just put into I. So as it's written now, it would not change how it's written. It would just move the red into the highlighted portion.
I'll give a thought or two on it. As you've already stated, there is no requirement in USPAP for such a rule. USPAP does require that the individual appraiser determines their own level of competency. And of course, the supervisor would have to be a part of determining that as well. I do not see any need for this rule whatsoever, and, that would be my thought on it. I'll let some others comment, but USPAP covers this without this rule being there. And one other thing, I think in terms of residential appraising, but general appraising, certainly there are general appraisers out there with trainees that do appraisal work much further than 50 miles. Now, most residential guys are not going much further than 50 miles, but the general ones are, and so this would benefit them if we removed it, I would think.
So if we removed this portion of it, the requirement would still stick for the 500 miles or until the supervisor determines the trainee is competent. It would just be regardless of distance.
Right, so if we remove this, the 500 hours is still required, or they're deemed competent. That is going to remain the same because that's what USPAP says and requires. This would just take out our state-specific portion that if it's more than 50 miles, their appraisers are required to accompany their registered trainees.
And you correct me if I'm wrong, but it's similar to the real estate industry. The real estate used to have like a 50-mile rule, and they eliminated that, didn't they?
Correct. The real estate, they used to have a 50-mile rule requirement. That was removed because we looked at other portions of the rules and statutes, and there are other ways that you can supervise an individual, and other rules and statutes that we could look at. Just like here, even if this rule is not there, if a supervisory decided that if you're my trainee and you go more than 50 miles away, I'm coming with you. That wouldn't be running afoul to the rule because ultimately you're responsible for that individual.
You need a motion?
I would need a motion to approve it, but I just wanted to know also, as it stands, so if we were to change this, the highlighted portion would be deleted. And so we would remove that part. My other question is, these are proposed rules right now and not rulemaking hearing rules. So I don't know how this rule, you are members of the industry, if you think this would be a controversial topic of removal. Because I viewed it as it being something less burdensome for the supervisory appraisers for their trainees. Correct me if I'm wrong.
It's a little redundant, like you said, because in the blue, it's talking about the trainee is competent, and part of that's geographical competency. So, just putting the arbitrary 50 miles on there doesn't seem to add anything.
Okay, well, then if that is what you guys would like, I just wanted to bring it back to you since this was a substantive change, and if it's a substantive change, I'm required to get your approval before I change it, and so I will need a motion and just a roll call vote, and that means that the highlighted portion will be deleted so that it will just say 1A, I'll just read it for purposes for the record. Accompany the registered trainee and personally inspect each subject property with the registered trainee on all assignments until the trainee has completed 500 hours of acceptable appraisal experience or until the supervisory appraiser determines the registered trainee is competent to inspect the property in accordance with the competency rule of the Uniform Standards of Professional Appraisal Practice, USPAP, for the type property.
I move that we accept the revised reading of this.
Second.
Motion's been made and second to accept the revision. Any further discussion?
I've got a question. Sure. So with the 500 hours, is that saying that that's the supervisor agrees to that, or filing the affidavit that they've completed the 500 hours?
So the 500 hours still applies, but this is more so about accompanying the trainee and personally inspecting. So they still have to do 500 hours, but you don't necessarily have to accompany inspect them if you have determined they're competent per use package. So this would help us get into compliance with the federal audit and just the finding, which required us to add that competency language there.
This seems, and I think this is Mr. Mansfield's question, this seems to say that if the supervisor considers the trainee competent before the 500 hours, they can do it before the 5. I mean, it leads the impression that they can. Look, the way it's written, is that, or am I reading it?
Could be more.
Well, but it also seems to imply that they could do less, and you're saying they cannot do less. 500 is the deal.
They still have to complete the 500 hours
Okay.
because that's a requirement, but whether they accompany them before or even after. So it can be, now it would be as written now, 500 hours, you don't have to go, but if you don't think they're competent after 500 hours, you can still accompany them further after that. So 600, 700, I mean, I'm going to stop, but you get the point.
My other question is, after they have completed the 500 hours, do they have to file something with the state? There's an affidavit or something. They can't just arbitrarily start doing it without notifying the state that,
Yes,
Okay.
none of that changes.
okay.
Anyone else? We'll take a vote. Roxana?
Chairman Randy Thomas,
Yes.
Dr. Warren McCara,
Yes.
Rex Garrison,
Yes.
Jim Atwood,
Yes.
Jason Bennett,
Yes.
Brett Mansfield,
Yes.
Michelle Alexander. Thank you. All in agreement?
Okay, thank you. I will get this changed and sent back for approval, and hopefully we can get this process moving, and we'll be before the Government Jump Operations Committee in 2020 to get these. Okay.
Thank you very much, Anna. Before we move on to legal, I'm going to exercise a little bit of my chair's prerogative, I guess. We have an audience with us, Mr. Don Turner. Stand up there, Don. He's kind of responsible while the rest of us are here. He started putting this association of appraisers together for our rules and our laws and our procedures, and we're kind of, I don't know if we should like you or hate you, but we're glad to have you with us, and I appreciate you being here.
To be perfectly honest, I have to blame this on most of
And tell us what your license number is.
number 11.
And what
My wife, she's one.
are we up to now? We're in the 33s or something? 5,000s? Is that right? Is that right? Well, okay, all righty. We'll move on to legal.
Okay,
We're on page 24 on your iPads for the legal report.
so if you'll notice at the top of the page, the legal report is from a name that you may not recognize. It's from Kristen Downey. So we have another attorney that's been hired. She's our litigating attorney, and she's the individual that compiled the legal report. You guys will get to meet her in January, but unfortunately she's not here today. So you guys are going to have to hear my voice for a little bit longer. I apologize. So we'll go ahead and start with the legal report.
What page does it start on?
24?
We are starting on page 24. So my first question is, we have several dismissals on here, and I know before in the previous we've motioned and gotten those out of the way. Do we want to go number by number, or?
Yes, for today, we're going to go number by number, if you don't mind.
Fantastic. Okay. Number 1, so we'll start with 2019-037071. Complainant is a homeowner. Respondent is a certified real estate appraiser. Complainant alleges that respondent conducted an appraisal of the property on April 15, 2019. As of the time of the complaint filed, the complaint was filed on April 30th, 2019. Respondent had not provided the appraisal report to complainant, even though respondent has been paid for their services. Complainant also states that respondent was 2 hours late to the appraisal. Respondent admits that respondent was 2 hours late to the appointment. However, complainant alleges that respondent called to inform. Respondent alleges that respondent called to inform the delay and told the tenants of the home would be there and to arrive when respondent could. Respondent alleges that respondent had not been paid for the appraisal prior to the performance, as the complainant alleges. Respondent states that the order was complicated because of the condition of the home. Respondent states that additional research was required, but respondent was very busy at the time. Respondent further alleges that there was a bay gate across the doorway of one section of the home. Respondent alleges the tenant advised that they were never told to enter the room because it was not safe, so respondent did not enter the room to measure or inspect. Respondent states that respondent was dealing with a family illness and was behind on several orders. Respondent further alleges that the respondent did not answer calls, texts, or emails because respondent left town unexpectedly and left respondent's cell phone at home. Respondent alleges that after respondent inspected the property, respondent contacted the lender to let the lender know of the home's condition and asked the lender to advise how they would like respondent to proceed. The lender advised respondent to proceed with the report. Respondent alleges that the property was an assignment for FHA appraisal and the property is in its state at the time did not meet standards. Respondent alleges that the entire complaint is false, except for the fact that respondent was late and unable to be reached for a few days. Complainant filed a rebuttal, alleging that respondent did not call to inform that respondent would be tardy. Complainant further alleges that the order was not canceled because the respondent kept stating the respondent was working on the report and would have it shortly. Complainant alleges that respondent was sent 12 past due reminders in addition to multiple voicemails, texts, and emails. The recommendation here is to discuss.
All right, you heard counsel's comments on this. I'll open the floor for comments, for discussion, I guess is what you've recommended. We discuss it, okay.
Kind of a he said, she said sort of thing, or he said, or she said, she said. Do we know what the facts are, really?
What's in the report? It looks like, well, the issue is, I talked to this one about with Kristen. We didn't know whether the fact that because the individual was late and never provided the appraisal, if you thought that maybe would be an ethics use PAP violation or a dismissal or a letter of warning or instruction.
The report was never completed.
No.
Okay.
But the complainant is not the client.
It's not the lender, it's the individual whose house is being appraised.
We don't know the agreement between the lender.
It's pretty safe to say, and you correct me if I'm wrong, the lender also did not file a complaint, is that correct?
I do not have record of a lender filing a complaint.
This sounds to me like a business decision, doesn't really have anything to do with USPAP. I move to dismiss.
Second.
Motion's been made and second to dismiss. Any further discussion? The only thing I would like to discuss or just say is I'm not even sure this falls within the realm of what we have jurisdiction over.
So you do have jurisdiction over it because it is a complaint against a real estate appraiser. And that includes some things that necessarily don't have to do with USPAP. So whenever, just for clarification, whenever we get a complaint and we would say no jurisdiction, it would be that it's not a real estate appraiser or it belongs to another board. So you have the jurisdiction and we don't dismiss complaints, solely dependent upon the content of them.
Okay. All right, motion's been made and second. Any further discussion?
Yeah, I'd like to say, from my point of view, this happens a lot. This is not, we don't ever see it here, but this is a regular occurrence in the appraisal management part of what I specifically do, 90% of the time, it's just a communication issue. The appraiser did something or is waiting on something, and everybody has a timeline of when they expect to get the report back, and then the report doesn't come back in that timeline, and you get a lot of delays. And sometimes the delays are completely on the appraiser, and sometimes the delays are completely because of the house, and it sounds like this is a house issue. We have been told in the past that there is nothing to be done, even if an appraiser just never turns the report in and doesn't communicate and just stops responding. So you're saying that that is incorrect. A complaint can be filed, and you would say it's an ethics issue.
I didn't know if you would think it would be an ethics issue. I read the ethics rule of USPAP, and I mean, I could make an
Very vague.
argument. It's a vague argument, but I mean, you know better than I do whether this kind of issue would fall into it. But there is no reason that any individual cannot file a complaint with the Real Estate Appraiser Commission if it pertains to an appraiser that is licensed with us or unlicensed.
Anyone else?
As what was mentioned, this is more a business decision, and it may fall to communication that they didn't let them know, but, you know, I made notes on this. This is more civil type dealings than,
Right, and if you think it's a civil matter, which sometimes it happens and it needs to be handled in another court, then that is also possible, but it does fall within our jurisdiction because it contains allegations against one of our appraisers.
Well, the appraiser needs to be given the adequate amount of time to complete the assignment, no matter what that is. If it's another 10 days or 20 days or 30 days or whatever it is, they still need to be given adequate time to do the research and complete the assignment if they're getting, going through with it.
Anyone else? Motion been made and second to dismiss. All those in favor say aye.
Aye.
Any opposed? All right, motion carries. Anna?
Number 2, 2019-044331. Complainant is a homeowner. Respondent is a certified residential real estate appraiser. Complainant filed a complaint against the seller's realtor, complainant's realtor, and the appraiser. Complainant alleges that complainant's home was listed as a 6-bedroom, 3-bathroom, but was later informed that the home could not be listed as a 6-bedroom, 3-bathroom home because of the issues with the home septic system. Complainant alleges that the respondent did not do their due diligence during the appraisal because respondent failed to inform complainant that complainant's home could not be listed as a 6-bedroom, 3-bathroom home. Respondent alleges that complainant stated the home was a 6-bedroom, 3-bathroom home. Respondent alleges that the septic permit was not readily available to the appraiser in the normal course of business. Respondent alleges that septic systems are generally not inspected unless there are signs of septic system failure, and the respondent did not observe any problems or concerns regarding the septic system at the time of the appraisal. Respondent alleges the documents were available in the normal course of business and did not specify the bedroom count. However, the owner of the home reported the home as a 6-bedroom, 3-bathroom home, and it was not. And this was also confirmed by the respondent's physical inspection of the home. This was sent out for expert review. Reviewer states that the construct of the appraisal was in line with USPAP and the work completed meets a reasonable standard of care. Reviewer further states that the physical observable room count included 6 bedrooms and agreed with the historical data, which included affirmation by the seller as to compliance of the septic system and the number of bedrooms. Reviewer further states that research from TDEC as to the septic system, septic data is not within the typical scope of work or required standard of care for a real estate appraiser. The recommendation is dismiss.
You've heard the council's recommendation. Discussion? But we'll make a motion.
Move to accept the recommendation.
Motion's been made and second to accept council's recommendation to dismiss. Any further discussion?
Yes, I do. the reviewer states that research for septic data is not within the typical scope of work required. I disagree with that. It is. If a property has a septic system, it's the appraiser's responsibility to conduct due diligence. Now, normally, this wouldn't be a problem, but in this particular case, it turned out to be, and I don't know. I'm willing for somebody else to either correct me on this or not, that, to me, the reviewer made an incorrect statement here. You see where I am on the last?
Yes, sir.
His last paragraph. The
Yes, sir.
reviewer says it's not typically an appraiser's responsibility to check on the septic system. The number of bedrooms, it would be his responsibility. That's my opinion.
Okay.
I would tend to agree with you. It also states, though, that it was in line with USPAP, so maybe an extraordinary assumption was invoked that we don't have, seeing that was in the report. I think that maybe it's a good point to bring up, because there is some liability on the appraiser in this standpoint, because the number of bedrooms a lot of times does impact value and marketability. So I think it's good to kind of put, does either need to be addressed in the form of an extraordinary assumption or go through the proper due diligence to uncover that.
Artie, anyone else?
The only thing I would say is that I'm going to vote no on this motion, but I don't know if it can be amended to a letter of warning. I think the appraiser needs to be informed, and the reviewer also needs to be informed that they need to check. It's part of due diligence for them to check on the septic system.
Anyone else? All right, motion been made and second to dismiss. All those in favor say aye. Aye. Any opposed?
No.
All right, motion carries by majority. Number 3. You don't have to read the whole thing, Anna. Just give us the highlights.
Okay. Number 3 is 2019-047821. So this complaint was opened by the Real Estate Appraiser Commission. It's an unlicensed real estate appraiser. So the complainant is saying that the respondent performed an appraisal without a license, and the Mississippi Real Estate Appraiser Licensing Board sent them a cease and desist letter. And the respondent said that the client was aware they were not licensed in Mississippi or Tennessee, and informed the respondent alleges the client informed them that was not a federally related transaction, and they could accept respondent's approval. Respondent states that they performed a market report for the property owner, and that the respondent informed the client they were only a licensed real estate broker. So the respondent is a Tennessee resident performing a real estate appraisal in the state of Mississippi, and counsel knows that respondent did not perform the complained of appraisal in the state of Tennessee. So the recommendation is a dismissal. They're pursuant to TCA 6239-103. It states that it's unlawful for anyone to solicit an appraisal or to prepare a report relating to real estate or real property in this state without first obtaining a real estate appraiser license or certificate. And because they were not performing a real estate appraisal in Tennessee, respondent was not in violation of Section 103. So the Mississippi Real Estate Appraiser Licensing and Certification Board should proceed with disciplinary proceedings.
Recommendation is to dismiss, or do I hear a motion? You want to discuss it, Rex?
Is it possible to send them a letter stating just what this states, just as almost a warning? Because it does state earlier that they're right on the state line, and this one was caught, but there could be some that's not caught, but just make them aware of what the law is.
So if we were to do that, I would recommend a letter of instruction to let them, to inform them instead of for that. So
Okay.
that is possible we can send them a letter of instruction stating this.
That's what I would recommend in a motion.
My question it would be, are they hiding behind market report? Just using another word for doing an appraisal? Did you see the appraisal, or did you see? I guess they didn't do one though, in the state of Tennessee.
They didn't do it in the state of Tennessee, so this was referred to us by Mississippi. So Mississippi is opening discipline against this person, and they let us know, and so.
Further discussion.
What kind of, I've lost the word, but anyway, if we do the letter of instruction, how can we enforce that? Because this is not a licensed appraiser.
It's not a licensed person, so it really wouldn't be enforcing it. It would just more of us say, hey, you're not licensed, but we know about it. So it wouldn't go. That's why I would recommend a letter of instruction, because we can't place it in the National Registry because they don't have a license.
Any law against impersonating an appraiser?
Not hold yourself out as an
Right.
appraiser. Like if you look at whenever someone is asking me whether they need a license or not, I refer them to the definition of an appraiser. And if you're doing the work that is under that definition, then you need a license. If you're not, then it's unlicensed activity. But the statute as written here can make an argument, because it's not in the state of Tennessee, we don't necessarily have jurisdiction over it because it was completed in Mississippi.
You don't need a license for an evaluation, so.
There's also that.
Yeah, but that's not for individuals. It's, and it states it's not an FRT, so an eval wouldn't kick in.
Anyone? Excuse me.
Federal-related transaction.
Okay, I do know that. Sorry.
Okay. All right. Do we have a motion? I don't even remember. Do we have a motion? Okay.
Yes.
Okay. Any further discussion?
I don't think we had a
Oh,
second.
we don't have a second.
Second.
I'm sorry. All right, we have a second now. Anyone else have discussion on this? Let's vote. All those in favor of council's recommendation, say aye.
Aye.
Any opposed? All right.
Yeah, the motion wasn't council's recommendation.
It was letter of instruction, just to clarify.
I'm sorry,
Y'all
because I had
wanted
dismissed.
to
Okay, so
revote.
we're going to do the letter. All right. My error. We'll need to vote again. Does that sound good?
It is.
Okay, instead of council's recommendation to dismiss, it's going to be council's recommendation to send a letter of instruction?
Yes.
Okay. Any discussion on that? All those in favor say aye.
Aye.
Any opposed? All right, sorry about that. Number 4. Summarize.
Try. I will do my best. Number 4 is 2019-050891. So the complainant is a Tennessee resident and homeowner, and the respondent is a certified residential real estate appraiser. So the complainant has made several allegations of multiple errors and omissions in the respondent's report. You can read those errors and omissions right there. Respondent provided a response alleging complainant wanted valuations of personal property, which is not within the scope of respondent's appraisal. And the respondent stated that they stayed within the applicable guidelines when determining the rating of the complainant's home, and that the appraisal was performed diligently with due care. This was sent out for expert review, and the expert reviewer made several conclusions, which are provided to you on the next lots of pages. So the recommendation based on the reviewer would be a consent order for 30 hours of continuing education coursework, comprised of 15 hours of sales comparison approach courses and 15 hours of report writing, to be completed within 180 days of execution of the consent order.
All right, you've heard council's recommendation. Discussion?
What were the classes that they took for the conditional dismissal? Do we have any record of that?
I can look that up for you. Hold on one
Okay.
second.
correct in saying this individual has already had a 2019, other than this one, filed against them?
So for the conditional dismissal, they took the basic appraisal procedures course, 30 hours.
Did they take that, or was that's what we told them to
They
take?
took it
Okay.
and signed it. It's been closed.
Floor is open for discussion. Accept council's recommendation. Make a motion.
I move we accept council's recommendation.
Motion's been made to accept council's recommendation on the 30 hours. Do I hear a second?
Second.
Motion been made and seconded. Now I need discussion.
I do have a question. Do you want this consent order education to count towards their continuing education or above and beyond?
Above and beyond.
Now I have a question. I thought anything, and you correct me if I'm wrong, I thought anything that we recommended as far as correctional education was not to be considered SCE.
That's correct. I just wanted to, double check.
Okay. All right. Ready to vote? All those in favor say aye.
Aye.
Any opposed? Motion carries. Thank you. Number 5.
Number 5 is 2019-05-3311. So the complainant is a Tennessee homeowner. Respondent is a certified residential real estate appraiser. So complainant is alleging that respondent was unprofessional, rude, short, and angry during the appraisal due to the complainant's real estate agent missing a phone call from respondent. And alleges that respondent exhibited bias and disdain for complainant's home and stated who even came up with this price anyway. Complainant also alleges that respondent did not pull accurate comparables for the square footage, and initially it was reported for 2,151 square feet as opposed to respondent's report, which says 2,108. Complainant says that the respondent pulled comparables for homes between 1,800 and 2,100 square feet and within their neighborhood rather than within a 5-mile radius. Complainant also alleges that respondent invoked Tidewater and gave the realtor the opportunity to find comparables to help with the final evaluation. So the realtor was unable to speak to a respondent other than to send comparables. Respondent alleges the homeowner is a disgruntled seller who had an uninformed real estate agent who did not perform their due diligence in the real estate transaction. The respondent states they never personally spoke to the realtor and that complainant was nice and asked several questions throughout the appraisal. They believe that a respondent alleges complainant explained that they made upgrades to the property and they informed them that they may not add to the value of the home. However, respondent alleges complainant stated they were leaving pieces of personal property, and at which respondent said that personal property was not considered in the purchase price. After they completed the appraisal, complainant inquired about the property value of the home and explained to complainant that when a new home is purchased with new constructions, often the sellers must compete with the builder as prices for new construction could be less per square foot than occupied units. Respondent states the Tidewater was invoked, which gives listing agents an opportunity to support their listing price with sales used in the listing process within 48 hours. And that the agent sent them within the time frame, but the sales did not support the sales price as they were new sales with no depreciation, meaning no properties had ever been occupied. So this was sent out for expert review, and you can see the expert reviewer's conclusions on the next 2 pages. Based on the expert reviewer's conclusions, we recommend that a consent order for 30 hours of coursework be issued, comprised of 15 hours of report writing and 15 hours of sales comparison coursework. to be completed within 180 days above and beyond their continuing education requirements.
Right, you've heard the complaint. Any discussion?
I noticed there was a mention of lack of, maybe it's just a box that wasn't checked on highest and best use, but is there any thought that maybe a course in highest and best use would also be appropriate?
I was thinking the exact same thing, that instead of the report writing, maybe a highest and best use. Is there a 15-hour highest and best use class? Okay.
Yeah, it's a market analysis, highest best use combined, which appears they would need that market analysis as well. Couple of thoughts on the reviewer's statement in the neighborhood section. Reviewer finds a section considered inadequate, but gives no examples. Statements in this section are canned, but he gives no examples. There's very little information about the neighborhood area that then the information in this section could be considered misleading. If you're going to, in my opinion, accuse somebody of misleading, you should give me an example, and he didn't. These are kind of generalized statements that we're supposed to take the reviewer's word for it. And I guess I'm just saying we need the reviewers to be a little more specific. Now, that he was specific in other areas, I'll give him that, or her, whoever. But in that particular section, to accuse somebody of being misleading and then not telling me how they thought they were misleading is misleading.
And this reviewer, who I'm assuming is probably the same reviewer as the last complaint, is very, very hung up on condition ratings, stating C3 versus C2 in the improvement section. That is very, very arbitrary, and I don't think something that they need to be paying that much attention to. Those condition ratings almost all blend together, and a house that was built 2 years ago can still be in a C3 condition based on how the people have lived in that home.
Assuming the homeowner is not an appraiser.
I don't know.
I just have a problem with somebody telling me that I'm using the wrong comps, and, qualifications are to tell me what the comparables are. So I have a mental problem there, I guess. Any further discussion? Any recommendation?
I'll make a motion that we accept council's recommendation, but replace the report writing with the 15 hours highest and best use class.
Our motion been made and second to accept council's recommendation for 30 hours, except we're going to replace the 15 hours of report writing with highest and best use, a 15-hour highest and best use class. We're going to continue the 15-hour sales comparison coursework. Any further discussion? Ready to vote? All those in favor say aye.
Aye.
Any opposed? Motion carries. Number 6.
Number 6 is 2019-055151. Complainant is a Tennessee homeowner. Respondent is a certified residential real estate appraiser. So the complainant alleges several inaccuracies that are listed below of respondent's appraisal, and they allege that the lender made respondent aware of the discrepancies, and that following this, respondent created another report with 2 of the 3 same comparable properties in less than 24 hours, which included a 15% change in square footage. Also, complainant says that some of the discrepancies were not corrected, and that the respondent failed to meet standards of the industry and committed ethical violations. Respondent alleges no specifications were available except for the tile flooring in the kitchen, bathrooms, and screened-in porch, and that certain specifications were in the bid sheet but would be completed after the after the appraisal was completed. They also allege that in situations where there's proposed additions or renovations, a room-by-room description is given with the improvements. Also, that when they arrived at the home, and the addition of the main level was discussed, but the upstairs was not. Respondents stated that they looked at the plans provided in the file and saw 3 floor plans, including existing first and second levels, and the first with proposed improvements. They used the first floor plans to assist in the actual measurements of the home. Respondent completed the inspection and scaled out improvements, which totaled 3,187 square feet, including the first floor addition, and they were with a room count of 8/4/3.0. Respondent alleges the plan showed 3,661 square feet, and legend with respondent inadvertently overlooked at the time respondent was preparing the report. They allege they researched the market for properties that were expanded and renovated to complete the report and emailed the lender on 5/22/19. They state that the original report did not include the screened-in porch in the first and second page grid. They also state that the site size was obtained from data from a local association and that takes site dimension and site size from the assessor's office. They state that the lender sent an email that the original plans were wrong and the owner sent several items the owner wanted to be considered in the report. Respondent states that the C2 rating was given because the property is old, 61 years old, without flooring, walls, exterior replaced. They state without the admission of the upstairs room count and gross living room area are inaccurate, and the second floor plan was separated from the first floor plan addition, which is why they initially overlooked it. Respondent alleges the sale original report was 4% higher than the original gross living area and 9% smaller than revised gross living area. They state the comparable 3 was renovated at the time of the sale and 5% larger than the appraisal living area and 8.5% smaller than revised gross living area. Also, that the 2 sales chosen were the best sales to compare the property in their opinion. They also allege the comparable 2 in the original report was totally renovated on one level with an in-ground pool. Respondent alleges comparable 2 in the revised report was replaced with a different property to bracket the property gross living area. And the comparative property is from a neighborhood with larger dwellings, superior in location, to complainant's neighborhood with much smaller dwellings. The property's gross living area was reported as 3,564 square feet per the assessor's office and 3,754 square feet per respondent's data and 3,684 per Paragon MLS. The respondent states that the 3,684 square feet was used for comparison. And the report was revised with 3,661 square feet of living area, comparable 2 placed in revised opinion value. So this was sent out for expert review, and there were 3 different conclusions made, which are provided before you. And so council's recommendation for this would be $250 civil penalty for various use PAP violations.
Heard counsel read the complaint, discussion.
Would it be appropriate to also require a sales comparison course for this person? Look like you're not agreeing with that.
No, I definitely agree with it. Where's the $250 civil penalty come from? Is
that was Kristen's recommendation. I believe she recommended a civil penalty, but if you would like to do education, which I know is typically a preference, we can.
That seems to be at the heart of the problem here, that there was inappropriate comparisons being made here.
The respondent already has a consent order from 2014 where they were required to take hours, and appears that didn't do the job.
Take them again.
Well, yeah, but I don't disagree with that. But you know, at this point, you've got to get somebody's attention. And $250 is not enough to get their attention, in my opinion. It'd have to be higher than that. I'm just throwing out some thoughts here, and then let somebody else discuss.
I just have a real question on how the respondent alleges a C2 rating on a 61-year-old house. That must be, somebody's done some serious renovation is all I can figure. I don't think that I've ever put a 61-year-old house as being a C2. That C2 is almost new. I would tend to agree with Mr. Atwood. I don't think 250 is going to get somebody's attention. If someone wishes to make any.
Make a motion. A civil penalty of $1,000 and a 30-hour sales comparison approach course.
Second that.
Motion's been made and second for a $1,000 civil penalty and a 30-hour sales comparison approach. Any discussion? Ready to vote? All those in favor say aye.
Aye.
Any opposed? Thank you. Number 7.
Okay, number 7 is 2019 057481. Complainant is a Tennessee homeowner. Respondent is a certified general real estate appraiser. So complainant alleges there was no communication from respondent for a week, even though the appraisal was conducted on June 11th, 2019, and that their realtor made several attempts to contact respondent. Complainant contacted their lender then following this. They stated that their lender had been trying to reach the respondent and that on June 26, 2019, the lender contacted the realtor stating that respondent could not find any comparables for the address. Complainant alleges the realtors for both the buyer and seller faxed comparable reports the appraiser to use, as respondent asked the lender to ask realtors for some comparables. Lender then contacted the real estate agents asking to send another appraiser, as the respondent had not been responsive to anyone. Complainant states they had to find another appraisal and begin the process all over again. Respondent alleges that respondent was in contact with a management company regarding concerns with the lack of similar comparables and that they do not speak with lenders directly. Respondent states that when they inspected the property, they asked the listing agent if they had any comparables due to lack of sales similar to the subject, and that the agent stated they did not have any. Respondent states that they didn't ask the management company or lender to ask the real estate agent for comparables. They also allege they do not have a fax machine and did not receive a fax with additional information, and that they did not complete the report because they did not feel the report would have been credible just to satisfy a closing date. Respondent alleges they did not intentionally disregard the owner's need to close. Recommendation is dismiss.
Heard counsel's read the complaint. Any discussion? This is certified general appraiser who's been licensed since 1993, correct?
That's correct.
Okay.
Yeah, it sounds like that they probably did the correct thing and withdrew from the assignment, so they didn't produce a report. I make a motion to accept council's recommendation to dismiss this.
Second.
Have a motion and a second to take council's recommendation to dismiss. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Number 8. Thank you.
Number 8, the complainant is a Tennessee homeowner. 2019 057961. Complainant is a Tennessee homeowner and respondent is a certified residential real estate appraiser. They're alleging that respondent discovered a 300 square foot discrepancy of complainant's home during the appraisal, and that the listing agent provided tax records and comparables after receiving notification of the discrepancy to show proof. They also allege that despite tax records and showing the discrepancy, that the respondent did not adjust the appraised value of the property. Complainant alleges respondent did not consider any upgrades or the irrigation system, and that they should reconsider the value of the property. Respondent alleges the measurements were shown 1,969 square feet in gross living area, and that the the property was marketed at 2,287 in gross living area. They allege that the listed gross living area was supported by local public records via CRS, and when the property was listed as new construction in 2010, it was marketed as having 2,005 square feet. They state the listing agent opted to market the home with the gross living area rather than the construction gross living area as new construction. They alleges that respondent alleges they contacted the VA and a listing agent via email noting enactment of Tidewater. The listing agent called respondent and talked for several minutes and volunteered to meet to discuss, but the listing agent declined. They allege that the public records may have been wrong and that tax records are not considered compelling support for determining gross living area. They also allege the upgrades and irrigation system were noted in the report. The reviewer states the respondent understands the appraisal process and the report is conveyed in an appropriate manner and provides sufficient information to enable clients and intended users to understand the rationale for the opinions and conclusions provided. The reviewer states the analysis and information presented enables clients and or intended users the ability to rely on and or understand the report. The recommendation is for a dismissal.
Heard counsel reading the complaint, and recommendation is to dismiss. Is there any discussion?
I move to dismiss.
Motion been made to dismiss.
Second.
We have a motion and a second to dismiss. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Thank you. Number 9.
Okay. Number 9 is 2019-062171. The complainant is a certified real estate appraiser. Respondent is a revoked real estate appraisal management company. They allege that complainant alleges they have an outstanding invoice and for $350. Respondent has not filed a response. A copy of complainant's complaint was sent on July 19th, and they did not send a response as of August to date. So the recommendation is dismiss. It appears to counsel that respondent's licensure status is listed as revoked. Counsel knows that this respondent is currently in bankruptcy status and further recommends that this complaint be closed and flagged.
Curious, what date was their license revoked?
The actual date?
Yeah.
Hold on a second.
The reason I ask, is this, and I don't even know if I'm permitted to ask this, is this the same AMC we did about 5 last time on?
Yes.
Okay, I thought so. Okay.
Has anybody filed, I know we talked about the bond, has that been filed? What's the status on that?
And I think we were going to do research on how the bond proceeding would go and give that. I don't have the status of that research. Give me a minute.
So it looks like they were revoked on, I think, 7/18/2019. So.
Remember anything about the bond? I think when we presented these cases, that was the question that the commission members had asked on how they can do the bond information.
That's what I was curious.
Yeah.
if that was all-
I don't have information, but I can follow up on that
Yeah.
and see if we can contact the.
We'll notify everyone who's filed this complaint against this appraisal management company and instruct them how to file.
Yes.
Further discussion? Council's recommendation is to dismiss. We have a motion? We have a motion? Okay, I need a motion.
Make a motion.
All right, motion's been made to dismiss. Do I hear a second?
Second.
Motion been made and second. Any further discussion on number 9?
I want to make sure I understand what's going on here. This idea of just declaring bankruptcy and getting out of all your obligations seems a little, I don't want to say easy, but it sounds like you're getting off easy on this. Now, you're talking about a bond being involved in this, so would the parties that have been damaged be made whole as a result of that?
No.
I was going to
Not even close.
Yeah, I was going to ask a question. I don't think, the AMC bond is not even for that purpose, is it?
It is for that purpose. What do we require in the state? I'm sorry, I have a lot of them. 25,000, okay. So what?
20,000,
I thought
even
it was-
lower.
Okay,
Yeah.
it's 20. And I've said this before, I think we need to change our law here to not require a bond, but require a payment into a fund that if an AMC goes out of business, just like Kentucky does, there are funds that are available. I think their statute is $150,000 or $200,000 that you can pay into the fund. AMCs have to pay it in lieu of getting a bond. And then if an AMC goes out of business or an AMC doesn't pay an appraiser, the appraiser can supply proof to the fund and get payment. The bonds are pointless. I'm sure the people who collect my funds every year for the bond don't think so, but I don't see how they ever work. Very few appraisers ever get paid, and when I fill out a bond request, I have to personally guarantee the bond. So they're going to go back and try and get their funds back from the company and/or gentleman who signed the bonds. He is bankrupt, and there's not going to be any money there.
I guess I'm not really objecting to the motion, but I don't know, it bothers me. They can just come along and do that, and okay, they're free and clear.
A legal question.
Yes.
If we put a civil penalty after the fact, that's after the date of his bankruptcy, would that be wrapped up in the bankruptcy, or would he have to file an amendment?
I don't know the answer to that, but I know, but since they're already revoked, we can't really do more than that. I think the unfortunate situation here is if we don't have an avenue beyond the bond, then the individuals that look at this are going to have to take other extraordinary legal measures outside of the real estate commission, as our statutes and rules are written. I do not know the implications of the bankruptcy, and that doesn't have any impact on our jurisdiction. So unfortunately, I don't know the answer.
Being that this was done before they were revoked, we could have a civil penalty.
We can't. We've already revoked their license, so we can't also instate a civil penalty. And I know with this particular company, we made an agreement that their license would be revoked. And this, I know that this is not, a civil penalty is not going to be paid. That's basically been what's been discussed when I had conversations with their counsel. So I think in this instance, it's going to have to be in a civil court with their private counsel, if anything,
So
following this.
what needs to be done to change the law, and can it?
So if they're changing the law, I think what you're talking about would be similar to a real estate, like an education recovery account, which our statute currently doesn't have. So legislative proposals for the year 2020 were already submitted, well, a couple of lots of months ago. So if we wanted to do something following that, it would have to be for the year 2021. If it were to come from the department. However, if it were to come from another entity, it is possible, depending on their timeline, what would happen. But as far as the Department of Commerce and Insurance coming from us, we would have to wait until the next legislative cycle.
How many licensed AMCs do we have in the state?
We had 153 the last time that we ran reports regarding the panel, and what will go out shortly.
If we did a $250 or $300 fee per year, I mean, that's $40,000. That would probably have covered the losses. And I don't know if it is acceptable to reach out to Kentucky to see how they're handling the claims, but I think it's something we definitely need to do.
Sad thing is, this is not going to be the last one of these that shows up in front of
Right.
us.
So I would recommend that if we wanted to do something about that, we'll maybe begin preliminary discussions in the next year about if that's something that we want to do, or look at some other research from other states. But as of the next legislative cycle, we're unfortunately unable to do that
Okay.
at that time.
In mind that your different organizations that represent the industry are very likely, would have more influence to be able to start something like that if it's something that industry-wide is, that is, those move quicker than moving through us. So that's what we kind of address at different meetings.
All right, moving along. Number 9, we have a motion and a second to accept council's recommendation to
I don't think we have a
dismiss.
second.
We
have-
do.
Yeah, we had a
Oh,
second.
thank you.
Any further discussion? Ready to vote? All those in favor say aye. Aye. All opposed? Motion carried.
Excuse me, I vote to abstain. I want to abstain from that.
To let you go. Okay, thank you, Doc. Okay. Move, number 10.
Okay. 2019-066131. Do you want me to read it, or do you want me to?
No, just
I'll
summarize
skip
it
to
real
the-
briefly.
Oh, or can I skip to the reviewer conclusions?
Just don't say the part about this is a Tennessee homeowner and he's a certified appraiser, because...
Well, that's important. So,
Okay.
I will try and summarize this
Okay.
as best as I can. So the complainant is alleging that the respondent is biased and unfair, and that they valued their home $10,000 under asking price. They're also claiming that the home is under the value of comparable homes. Complainant also states that they gave the listing listing agent opportunity to justify the value, but respondent ignored their comparables. And the respondent waited to the last day to send the appraisal. And that the respondent was over 2 hours late to the appraisal. And because of this, the closing had to be pushed back. And that the transaction was possibly almost closed because of it. Respondent states in their response that they were late to the appointment, but was told that no one was going to be at the property, so they did not know that they were waiting, individuals were waiting on them to respond. They also state at the end of their walkthrough, they asked about repairs the complainant was making, and asked about the discrepancy in the square footage. Respondent alleges the property measured at 1,636 square feet, but the property was listed as 2,013 square feet. And that respondent and the complainant admitted the garage was once a living space when they bought the property. Also, in discussing the discrepancy, complainant expressed the home was not priced because of square feet, but based on bedroom count. And respondent states that the sales found did not support the contract price, and respondent would have to invoke Tidewater and give the listing agent the opportunity to provide supporting information. They also state that around August 16th, 2019, the MLS listing was changed to report the square footage as 1,650, and they provided 3 additional sales, and of the 3, only one was within a mile of the subject and was a log home, which was not comparable to the property and not considered. Also, the 2 additional comparables were located more than 2 miles from the property and in different schools than of the other subject. Respondent states they were informed the client the most relevant comparable have been utilized within their appraiser's report and provided most credible results. And the listing agent provided a list of sales saying within 2 miles of the subject, but only focus on smaller homes which indicated larger price per square footage. They also state that the home had sales prices between $130,000 and $141,000, supporting the current contract price, and that they had to inform the lender the additional sales were not the best comparables. This was sent out for expert review. The reviewer states that there are no issues that would qualify as violations of USPAP, and therefore the recommendation is dismissal.
And the recommendation is to dismiss. Any discussion? Recommendation?
Accept council's recommendation.
Second.
Motion been made and second to accept council's recommendation. Any further discussion? Ready to vote? All those in favor say aye.
Aye.
Any opposed? Motion carries. Thank you. I just have one quick question before you start number 12.
11.
Oh, 11. I'm sorry. Question at all? No, I do.
Okay.
Is this the same individual from number 4?
No.
Okay.
Number 11 is 2019-067461. Complainant is alleging that respondent violated their privacy and that the lender ordered an appraisal and the assigned appraiser was an individual complainant has had prior issues with in a personal capacity. Complainant alleges that they were contacted by respondent's office and immediately informed respondent's company that complainant did not want to do business with respondent. Complainant alleges respondent called complainant back and explained they did not know of the assignment and that respondent violated complainant's privacy by calling the complainant. Respondent stated they received the order and that respondent's company contacted complainant and discovered a conflict of interest. Respondent contacted the complainant to let them know the same assignments were made at random and that the conversation was professional and courteous and no inappropriate comments were made. Respondent alleges that there was no way for a lender or appraisal company to know of their relationship with complainant as orders are assigned on a rotation and at random. Recommendation is for dismissal.
Heard counsel read the complaint, and counsel recommendation is to dismiss. Any discussion?
Move to accept.
Motion's been made to accept.
Second.
Motion's been made and second to accept council's recommendation to dismiss. Any further discussion? Ready to vote? All those in favor say aye.
Aye.
Any opposed? Thank you. Now, number 12.
Okay. Number 12, 2019-056821. Complainant alleges respondent inspected the property with the buyer, exchanged numbers, and continued communications with the buyer. Complainant alleges that respondent requested a copy of a full home inspection from the buyer, and that respondent listed all the repairs as a contingency in their appraisal and personally advised the buyer that the buyer should not buy the home and that it wasn't worth it. Complainant alleges that the buyer showed the agent text messages of ongoing conversations between buyer and respondent and informed the agent that buyer had been communicating directly with the respondent. Respondent alleges complainant was given the opportunity to place an accurate listing price on the subject property at the beginning and end of the real estate transaction, but the agent failed to do so, and that they inspected the property alone. They stated there were cameras around the property to verify this information. Respondent states after they concluded the inspection and leaving the property, they noticed that a car was at the end of the driveway and that the buyer was inside the car and approached respondent. Respondent states the buyer spoke about moving to Tennessee from California, and the seller allowed the buyer to leave their horses on the property. Respondent alleges during the conversation, complainant offered respondent a copy of a home inspection report. Respondent admits appraisers do not typically have access to home inspection report, but respondent was interested in the information, and they gave the buyer respondent's contact information in order to obtain the report. Respondent alleges they issued a Tidewater notice. They also allege that buyer later contacted respondent and asked about the status of the report. Respondent alleges the buyer was advised to consult with the real estate agent and did not release any pertinent information regarding the appraisal to the buyer. Respondent alleges that the only other time buyer reached out to respondent was to ask about respondent's hairstylist information. Respondent alleges respondent stated the home was not worth the price by providing the appraised value, and that they never stated those words verbally to the buyer. Recommendation is to dismiss. Without further information to substantiate complainant's claims, counsel recommends dismissal.
You've heard counsel read the complaint. Her recommendation is to dismiss. Any discussion? Anyone wish to make a motion?
Accept.
Second.
Motion been made and seconded to accept council's recommendation to dismiss. Further discussion? Ready to vote? All those in favor say aye.
Aye.
Any opposed? Thank you. Number 13.
Okay, number 13 is a represent. So the number is 2019-0086-8961. So I will skip down to the new information. So counsel sent out a request for information to the respondent, and the respondent issued the responses that are listed below regarding the request of the commission. It appears that to counsel that assistants are given the authority to affix signatures to reports regularly after the report is checked by the appraiser for accuracy and errors. Since respondent requires the appraiser to perform a final check of the report before the appraiser's signature is affixed, it does appear that respondent gives authority to the assistant to affix signature to the report each individual time a report is submitted. Therefore, counsel resubmits their letter recommendation for a letter of warning.
Out of curiosity, what's it being represented to us for?
At the conclusion of the last meeting, the commission requested that we send this matter out for investigation to obtain information about the assistant signing the paperwork and the responsibility of the respondent and their office policies regarding assigning the reports. And the information that's provided and new information is what was obtained from the request for investigation.
Any discussion?
Yeah, I remember this one. The respondent, and they've admitted that their staff signs the reports for the appraisers. That's okay as long in USPAP, as long as the permission is given each assignment. You can't give a blanket, you can sign all of my reports. They have to give permission each assignment, and they're saying they did that. However, I think they're potentially on very shaky ground with this. I don't know. A letter of warning should be, I would agree with at least a letter of warning in the sense that they need to visit USPAP's instructions on this and be sure that they're in compliance with it.
A letter of warning goes on their record, a letter of instruction just.
Okay, yeah.
So I was sort of leaning towards a letter of instruction, pretty much laying it out. You better be careful.
I'll be okay with that.
I have a question. The disciplinary history of 2019, is that what we suggested last time or something above and beyond?
It's a completely separate matter.
It is a completely separate matter.
Yes, so they have
Okay.
a 2019 consent order as well.
All right, anybody want to make a recommendation?
I would recommend the letter of instruction specifically regarding USPAP's concerns regarding signing reports.
Second.
A motion's been made and second to issue a letter of instruction. Any further discussion? Ready to vote? All those in favor say aye.
Aye.
Any opposed? Motion carries. Does that conclude legal?
Yes.
All right. Roxanne, how long do you think the rest of it will take?
Depending how long we are going to discuss your conference you attended in Aero and the update from the financial institutions, half hour to 45 minutes maybe
All right,
total?
let's take a 10-minute break.
Okay, thank you. We are on the record. Go right ahead.
All right, let's call the meeting back to order.
Good luck.
Proposed rules, we've already gone over that, haven't we?
We have. We're on the director's report.
Okay, director's report.
Thank you. If you will turn to page 97 on your iPads, the first piece of business we'll go over is meeting dates scheduled for 2020. If I have not emailed these to you, I will as soon as I get back in the office today, so you can mark your calendar. The only change is the October meeting, which normally we have the second Monday. We wanted to make sure to not clash with the Aero conference in October like it ran into this year. So we do need a motion to accept those dates, and then we will publish them to the website.
I was going to throw out, move the October meeting to November.
Oh, that would be at your discretion.
I would
What's the
second
problem with that? What's your rationale?
Yeah,
What's your rationale?
Well, multiple reasons. One, the Aero conference. Two, October is typical fall breaks, and October's a lot busier than November.
Okay. So is that acceptable, Roxanne, to move?
As long as you have 4 meetings in the year, it's perfectly acceptable. So let me open a calendar for 2020 so we can at least tentatively pick a date.
16th? How's the 16th look for you?
So you normally meet on Mondays. It would be, oh, I'm sorry. I'm on the wrong year. We need to move ahead here. The 16th was,
Week before Thanksgiving, so it wouldn't kind of get tangled.
You'll have to bring a turkey, Doc.
I'm sorry?
You'll have to bring the turkey.
Well, I better not say anything.
the 9th or the 16th would work. Either one. It would be at your discretion.
Let's do 16th.
November 16th. We have to vote on this?
Just the entire 2020 calendar. So
Okay,
we
we're
would-
going to move, we're going to eliminate October the 12th at the bottom, ladies and gentlemen, and move it to November the 16th. This is all 2020. Hang on.
Hold on a second. 2020. Are you looking at 2020? Oh. So we have another program that Anna's the attorney for on the 16th. Would the commission be okay with having it on November the 9th?
Gotcha.
Okay. Is that okay?
Okay. All right, moving October the 12th to November the 9th, 2020.
The 9th?
9th.
Okay.
Can you be here? Bring the turkey anyway.
I don't know. It's too far into the future. I don't know. I don't know what I'm doing next week, let alone next year.
Okay.
So that doesn't interfere with, no, election day's the 3rd, never mind.
Okay. Need a motion to accept the new calendar for 2020?
So move.
Second.
Motion been made and second to accept the new calendar with the bottom date being changed to November the 9th. Any discussion? All those in favor say aye.
Aye.
Any opposed? All right, we've got our new calendar set. Thank you.
Thank you, and I will send that to everyone and then get it posted on the website. Next, we are looking at our budget piece. On your iPads on page 89, you have the 3 years, and this is based on fiscal year, information showing us with a reserve at the end of the fiscal closure for 2019. We ended with $2,379,497, which is a slight increase from the previous year, but obviously much slower. That's not a bad number, given the different sunset hearings that I've gone through. The thought is somewhere between 2 to 2.5. What you need each year to operate is what you would want to have in your reserve, and I think we're well in line with that. On page 99 is a different view of the breakdown, and this gives you, this is what we're getting each month, showing that we finished fiscal year 2019 with $59,928 extra. So that's pretty good between what we took in and We have some additional expenses that we'll be seeing for technology, but nothing big. Any questions on the financials? Okay. Next, I have, this is just information. We don't need any type of motion. On page 101, I started with your closed complaints. This matches what is printed on the disciplinary action report that is on the website. The disciplinary action report is printed monthly for anyone that wants to see. And those are your closed cases with consent information, summary of the case, as well as information on the individual. And then your open cases are on page 102. So these open cases would reflect all of the ones that you heard today and those that haven't been closed yet from last month. And this is just to give you a visual of what you have on your complaint side. I have no questions. We'll move on to new business. I think we just had 2 items that I have, and anything else that the commission has we can discuss. All right. First item that I have for us to definitely cover is the October 15th meeting that was held. This would be the update on the joint effort between the fiscal institutions and the real estate appraisers. And Commissioner Rex, I will turn it over to you so you can give us an update. And
we had about 100 in attendance. The ratio, I want to say it was between 30 and 40% bankers, the balance appraisers. Overall, it went extremely well. My impression in talking with the bankers, they thought it went extremely well. The hope is that this is a beginning, and we've talked about a couple of options just during the meeting as far as on breaks, possibly doing combined CE between appraisers and bankers. Also, the meeting was very heavy for Middle Tennessee, and maybe taking something east and west to bring in bankers and appraisers from other parts of the state.
And I know several other commission members went. I appreciate that. That was great. And neither Jennifer nor I were able to go, so Caleb enjoyed and got a lot out of it as well. So that was good.
Just one point that Rex, just for the record, should be applauded for his efforts. It was a lot of work that he did in conjunction with the Bankers Association, but a lot of work behind the scenes, and so I wanted to thank him publicly.
And I agree. Just to get that to happen and have the meeting take place is a lot. So thank you. And next but not least, Chairman Thomas was able to attend the Aero conference. We had sent out, because in July we actually missed the date and didn't discuss it, we sent out emails so that anyone that was interested and able to go could travel and be approved for that. The only person that was able to was Chairman Thomas, so I do need a motion approving his expenses.
Now you tell me.
You knew. You were the only one that could move meetings around, so we appreciate having somebody vote on behalf of Tennessee. So Randy was able to attend, just got back, I think, yesterday to home, and is back on the road to get here. So really appreciate that. So we do need a motion, Bruce.
So moved.
Second.
Thank you.
Sorry.
I guess motion's been made and second to approve that. Any discussion? All those in favor say aye.
Aye.
Any opposed, please show that I did not vote. Wanted to.
There you go. And we welcome any feedback, Randy, that you want to share from the meeting. I know we're getting closer to the live date with the AMC rolling out and needing to, by June 4th, 2020, have the payment of the panel information. So I don't know if that also was covered, but anything you want to share with the full commission?
Sure. I had a chance on Friday to go to the ASB and the big talk there, everything was on the disclosure letter that's gone out in regards to evaluations. And it's a mixed bag. First off, I'll tell you there's probably 10 to 12 different definitions for evaluations. Some states do it totally different than others. Alabama has passed a resolution to where evaluations has nothing to do with appraisals. So and it doesn't matter if you put a value at the end, they don't come to their board. They're not involved in evaluations in any form or fashion. That was probably the big talk at the ASB. I will tell you, one of the things I guess I learned, they had a USPAP seminar, I guess is what you would call it. And the interesting thing about the topic there was USPAP is a do document, not a you do not do document. And so if it's in USPAP, by God, do it. And that's kind of where we're running into here is we have people who, A, don't know USPAP, and B, don't follow it if you do know it. So that was a big deal. The other thing that I found incredibly interesting, and I talked to some of the commissioners, was that when an E&O insurance company contacts you and says, have you ever had a complaint filed against you? It doesn't matter whether it was dismissed or what it was, but if you've ever had a complaint filed against you, you have to disclose that before you get the privilege to find out what your E&O premium is. And if you don't know, if you ever had to use E&O, and knock on wood, I have not, your E&O insurance premium is probably going to change. But I know that Kentucky and Indiana and Ohio have changed the verbiage to where when somebody sends in one of these alleged misbehavings, let's say it by an appraiser, they call it an allegation or they call it a grievance instead of saying you've had a complaint filed against you. Because what you said a while ago really concerned me in regards to because it's an appraiser. So somebody said, I wore the wrong color tie to their house. Because I'm an appraiser, you have to look at that. And that's a, quote, complaint. So there's about 5 or 6 states that have changed the verbiage to say we have an allegation filed or a grievance filed, so you don't have a complaint. And when it's dismissed, it's dismissed. I mean, it doesn't show up anywhere. It's dismissed. And I thought that was great because I know when you have something that's what I would consider to be frivolous, it stays in your file. And as one who does a lot of litigation, I always encourage attorneys on the other side to check out that other guy so that, I can use anything I can because everything we can. So I thought that was kind of interesting the way they did that. Biggest concern across the country right now is, I don't know if you know it or not, Danny Wiley, who was from Tennessee, has gone. He's second in command at Freddie Mac now. He left his AMC and he's second in command at Freddie Mac. There was a big discussion there as to Freddie Mac and Fannie Mae realistically, all they're looking for is data. I mean, and I was telling Rex, we argued back and forth or had some heated discussions as to credibility, and it's very unfortunate, but I got the impression that credibility is way down the list. That really concerned me. But overall, I had a good time. We met there. They had a president's reception like they always do, had some good speakers. There's a lot of times that are very dry in those meetings if you've never been. But it was good. Another interesting thing that I found, and for all of you, I want you to know, and that is that Mississippi, North and South Dakota, North Carolina, and somebody else, they send their entire commission, plus the attorneys, the janitor, and the dog catcher, and I mean, they had 10 or 12 people there from each state, so I kind of felt, said, Yeah, Tennessee is sitting over there. I thought, maybe I forgot to use my deodorant or something. I don't know, but I was kind of over there by myself, and they had crowds over there. So I'd like to see we go to San Antonio in, I believe it's spring, but I think it's either April or 1st of May. But when is it? April. But our meeting will be in San Antonio. So I would encourage, try to clean your schedules to where you can get to these things. These are really eye-opening.
You have the date, Rex?
And it should already, as far as the date, should be on the Arrows website, because they're the ones that put this together. And it definitely at your January meeting, you all need to vote on who you think can go. So if you'll look at
Would
those
it be
dates.
possible to send more than 2?
I think it would. I don't know that the philosophy would ever be to send everyone like Mississippi does. I think just to be prudent with our money, we tend to maybe take turns. Half of you could go, or 3 could go at spring, and then year-end, the others that didn't go. But definitely 2 or 3, I don't think that would have a problem being approved. I think more so we've run into just everyone being busy and the dates not working. So we can always ask, but definitely at the January meeting, make sure that we vote on who's able to go.
You know the dates, Anna?
April 3rd through 5th.
April
Thank
3rd. April 3rd through 5th. But it'll be in San Antonio, and that's a trip worth making. But the education, they bring in the speakers from everywhere. So that's pretty much my report from D.C.
That's all I had. I will.
I move we adjourn.
Second.
We have a motion.
Thank you.
And a second to adjourn. All those in favor, take the action and leave. Thank you. Appreciate everybody. Thank you very much.